welcome. This is Face the Nation. It's a Monday night. We're coming to you live and direct from our Stein Studio Complex here in Ratmalana. My name is Sonali Kwanika-Babuke. Now, controversy continues to surround the free trade agreements that the government not only plans to enter into, but those already entered into. Is there merit to the various claims, contentions being made by politicians on the one hand, professionals on the other, and even laborers? Or will these free trade agreements unlock the doors to progress and prosperity? Today's discussion focuses on that and how exactly is Sri Lanka supposed to move towards economic growth, economic development, where in a day and age where we're moving towards accelerated growth and accelerated development. Very quickly, let me introduce our guests this evening. We are joined by Dr. Anand Ranasinghe. He's the past president of the Institute of Engineers of Sri Lanka. Good evening and welcome, Doctor.
Good evening.
We are also joined by Professor Rohan Samarajiva, who's the chairman of ICTA, ICTA, and chair of Learn Asia. Good evening, Professor.
Good evening.
Our third guest, a first-timer to the show, Mr. Kanishka Vitharana, attorney at law. Good evening, Ms. Vitharana.
Good evening.
Great to have you with us. And also, last but not least, Kithmina Hevage, research officer at the Institute of Policy Studies. Good evening, Kithmina.
Good evening.
To have you again with us. My first question is to Kithmina Hevage. Kithmina, we keep talking about accelerated development, we keep talking about free trade agreements, the need to move towards development in Sri Lanka. However, at the existing juncture, there's a lot of policy inconsistency, policy reversal that we're dealing with. These are issues that Sri Lanka has been grappling with for some time now. So, in your opinion, should Sri Lanka first put its house in order before moving to these high-tech, like very posh free trade agreements? That's my first question to you.
Well, I don't think it's mutually exclusive. I think we can put our house in order while also moving towards the future and engaging with a more global world. I think so. Things like policy consistency or addressing policy inconsistency is something that can happen at the same time while we lock in certain commitments and ensure that we strengthen our connections with other countries. So, for example, a way of actually ensuring that there is policy consistency are these free trade agreements, are these agreements or multilateral agreements that we sign on to, because then we make somewhat of an international commitment that is legal and binding to an extent, and therefore the policies are protected from kind of the vagaries that happen due to the political process. But I think overall it's important that the political process, the economic process, is insulated from politics. I think that's the fundamental weakness in the Sri Lankan system right now, because economic policy is driven by politics rather than politics being driven by economics. I think the famous saying while Bill Clinton was running for president in '94, I believe, was "It's the economy, stupid," which showed that it was the economy which was important, and economic priorities and the welfare of the country, particularly for the future generations, were important. I think the problem right now is that due to political factors, multiple governments since independence seem to have prioritized the quick fixes, the debt-led development strategies. And because of that, Sri Lanka is in a certain economic predicament when it comes to its debt obligations, when it comes to its export competitiveness, which have all been a burden on the economy. So I think given that situation, we need to think of economic and making the investment climate, the business climate, more friendly to both domestic as well as foreign investors. I think things like free trade agreements and other international commitments that improve our market access, solidify the commitments we make to international standards, and also create the confidence that is needed between us and the international community that Sri Lanka is a place where they can invest and be secure in their investment. So I think I think the question rather is kind of, can we prioritize one or the other? I think it's something that we need to, it's not mutually exclusive, and it's something that we need to focus on in order to make Sri Lanka's economy more competitive.
Right, Kitmina, thank you very much for your opening remarks. Beginning the show on a positive note, I move my attention to Dr. Anand Ranasinghe, past President, Institute of Engineers, Sri Lanka. Dr. Ranasinghe, you have been quite critical of the most recent FTA signed between the governments of Sri Lanka and Singapore. One of your main concerns that you raised was the fact that you haven't been consulted, your institute hasn't been consulted properly, your recommendations haven't been taken into account. Just to give us a recap, and as a precursor to this show, what exactly are the contentions that you have with the free trade agreement between Sri Lanka and Singapore?
Now, this is the very first time where Sri Lanka entered into a free trade agreement extending the services as well, because earlier what we had was, we had an agreement with India that restricts only to goods. So therefore, as professionals in the industry, we are very concerned about this extension of service industries due to various reasons. First thing is actually, nobody has done a survey up to now whether we have a surplus of engineers or whether there is a shortage of engineers in also other professionals also. And sometimes actually there are, personally I know there are a lot of people, engineers, very difficult to find jobs. There are surplus of engineers. So therefore, and also working in another country, for example Singapore, by a Sri Lankan engineer, although at one time it was not that difficult, now it's going to be extremely difficult because they are very strict on qualifications of engineers. Now unfortunately, this Singapore-Sri Lanka Free Trade Service Agreement, they have extended to bring services, and also while they are extending, they have categorized certain people, those whom can work Sri Lanka if they are coming from Singapore. For example, they say managers, experts and executives. Now the definition, when you say managers, experts or executives, definitely their qualifications and their speciality should be of very prime importance. But basically what we have agreed is that as long as they have worked as experts in their country, they are qualified in an organization for more than 5 years, they are qualified to come and work in Sri Lanka. So therefore the definitions of this free trade agreement given to the Singaporeans are very, very vague, in the sense anybody can call themselves an expert and come and work in Sri Lanka. But supposing if a Sri Lankan wants to go and work in Singapore, they can't automatically say that they are experts because they have worked in an organization called experts, because they have to subject to the conditions and various things in Singapore, because they have to get licensed to work in Singapore. So therefore, extending services we feel is very arbitrary. Now, Institution of Engineers also have participated in several discussions with at these meetings with the Ministry of Strategic Development. And although we were participated in discussions, our proposals were never considered, I would say, because always we go there, but final decisions have been taken by the ministry. So therefore, we are very concerned about this one, not only in respect of the professionals, in respect of other trades as well. For example, this is going to expand even to hire people, etc. So therefore, especially in respect of professional roles, we are very concerned about the Singapore agreements, because although the government claims there are a lot of advantages to us, we feel there are a lot of disadvantages, and it outweighs the advantages.
Very quickly, Dr. Ranasinghe, have you, post-signing of the FTA, has your institute raised these concerns with the ministry?
Definitely. Actually, we have we met the minister on one occasion, and also through the institution we wrote letter to the minister. But although in public statements, although minister states that we have been consulted and our views have been taken seriously, we would say it has not been done. most of the agreements, and we were against extending the service industry, especially in respect of professionals. But it has been done without our approval or without our consent. So therefore we say, although we have been consulted, the minister has not listened to the views expressed by the professional institutions like IESL.
Thank you very much, Dr. Ranasinghe. Professor Rohan Samarjeeva, you're now the chairperson of the ICTA. Free trade agreement between the governments of Singapore and Sri Lanka. What are the benefits that you see which could take Sri Lanka to the next level in terms of technological development?
I'll begin by saying that I have been speaking on trade agreements from 2010 or 2008, and that has been in my capacity as somebody who has studied trade in services in particular, whose first published article in this area was somewhere in the early 90s. And as somebody who was involved in trade negotiations. My current position has zero to nothing to do with trade agreements. So I'm speaking as a person who knows the subject, rather than representing a government organization. Now the issue with much of the debate about trade agreements is that we are setting completely different yardsticks for judging them. Trade agreements in the 21st century are about providing certainty, for investors. It's not about minimizing trade deficits or increasing trade surpluses, or about obtaining the right number of professionals in a particular industry or anything like that, right? These are framework agreements within which private actors will be doing various things. So for example, if you look at the particular area that has come up in discussion, which is the movement of professionals under services. Now one thing I have to say is that in the 21st century, nobody actually signs goods agreements, pure goods agreements. Because now goods and services are so intermixed that all the agreements that are being signed involve both goods, services and investment components. That's just the way the world is. So within this, the controversial issue is about movement of people. Now you can have, again what is not stated is that services agreements are negotiated very differently from goods agreements. So here we have what is called the positive list approach. That is, we list the particular sectors that are being covered, and anything that is not listed, for example, medical services, health care services, hospitals, are not included. I'm puzzled as to why there's a lot of confusion, a lot of engagement by medical professionals on that. But when it comes to the areas that are covered, the most liberal opening has not been done. What has been done is the most restrictive opening. And I have said in public that I think it's too restrictive to really allow for proper technology transfer. Because you don't bring people here to fill jobs. You bring professionals in for tacit knowledge that is embodied in themselves. So technology transfer doesn't happen with explicit knowledge, but also with tacit knowledge. Tacit knowledge comes with people. So in this, we have only opened up the intra-corporate transferees, and that has been very restrictively defined. So just to give an example, the comprehensive agreement between India and Singapore allows only for 6 months in the firm before they can be brought in. Here it says 12 months. So this is more restrictive even than the Indian one. Now for people like me, I don't actually work full-time for the government, and those days I used to work as an independent professional, providing consultancy services all over the world. Now I would never be covered by this kind of agreement, because in some agreements independent professionals are covered. But this doesn't cover independent professionals. This covers only intra-corporate transferees, which is an extremely restrictive thing, which requires a firm in Singapore to have another branch here in Sri Lanka.
Professor Samarajiva, thank you for that response, but I would like you to don your hat of the chairman of ICTA when answering this. There's a lot of concern among IT professionals that there's a huge risk to their jobs through the signing of these free trade agreements without proper consultation. And to those allegations, what would you say?
There's also a huge risk about not having the right skill mix. So, for example, if you're bidding for any work and you're putting together a bid, because a lot of these firms do bid for work, right? When you're putting the bids in, you have to say that you have certain skill sets. Now, it's possible that we have 24 of the skills that are needed for a successful bid, for which you get points, but there's one particular area where we are lacking. Now, in these cases, you use a free trade agreement, or you go to the immigration department, to BOI, and get special authorization to fill that slot, so that you can take on that particular work. Because this is how competitive bids from Sri Lanka, from Singapore, from all over the world, people do bid for this work, and they get points depending on the skills that they assemble. Now, I personally have done this, bid for work with people from multiple countries. But what a free trade agreement does is that it provides a certainty within which these firms can get those authorizations. So I think that instead that also is a risk that has to be put on the balance.
Right, thank you very much. My fourth question is to Mr. Kanishka Vitarna, attorney at law. Mr. Vitarna, it is a state's responsibility to ensure that domestic industries are protected through a robust framework to guard against unfair trade practices and unforeseen surges in imports. I'd like to ask you to very quickly explain the implications of the Anti-Dumping and Countervailing Act and Safeguard Measures Act in the context of free trade agreements.
Yes, now we'll see. Thank you for inviting, first of all. This is my first assessment, as you said. Now, anti-dumping and countervailing, if I start with that, it is, I don't think, have much impact on it, because when you compare the four corners of the agreement, this covers so many areas, including investment goods, investment services, as my Mr. Professor said. But before reaching all these things, we have to see, as you said, the government of Sri Lanka, or any government who's entering into agreement, has a duty by the people and the nation. Now, in constitutional terms, we have to see, now there's a concept called sovereignty of the people, of the country. When we are entering into an agreement, a free trade agreement, it's the duty of the state to see that our sovereignty is not intact. It's like this. Now, in the context of the sovereignty, there's a subclass of sovereignty. It's called economic sovereignty. Now, when it's all right, now here there's no dispute with regard to entering into free trade agreements. The allegation or the criticism that arising on this agreement is that when the government has failed to make this agreement into a win-win situation. That is, there are preliminary matters that have to set out in a country to qualify to enter into a free trade agreement like this. Now, for example, you said, the first question you posed was whether we had a trade policy, and in the home we are have we constructed the necessary legal framework Those are essentials. And as it inspired during the discussion, have we consulted the necessary stakeholders? So those are necessary ingredients. Then it's a duty of the negotiators to assure that we first fulfill the preliminaries to get ourselves in par with the negotiating party. So in this case, we see that we have not shown our skills. Our expertise have failed in this exercise to maintain that equality between the trading party. As a result, the outcome of this entire agreement is disadvantageous of us, especially because our country, our officials has failed to do a preliminary feasibility studies. What are the advantages of it? What are the disadvantages? What are the laws covered by it? What are the other agreements? Now we intend to Singapore. Now we have to evaluate what the impact of other agreements, that the trade agreements that the Singapore had entered into with other countries. So these agreements are also have an impact on us. So truly, because this agreement provides for that. Apart from that, our country has sufficiently followed the legal procedure to comply with the constitutional requirement of prior to entering into the agreement. That's also, I very regret to say that we have failed. Our state officials failed in that exercise also.
Thank you, Mr. Vitharana, for your perspectives. Now, some of the other issues that we'll also be focusing on will be the future FTAs that the government of Sri Lanka hopes to sign. There's one with China, there's another with India. These are in the pipeline. Also, does Sri Lanka really utilize the experts that we have at the negotiating table? Do we have the necessary negotiators to negotiate the technical terms and conditions on behalf of the country to ensure that the country's best interests are ensured? And the other issue is, when it comes to consultations, are there multiple stakeholder consultations? And even if there are these recommendations taken into consideration? So these are some of the areas that we'll be focusing on in tonight's discussion. I open the floor for questions from Charitha Fernando and Naveen Majid. Charitha, let's start off with you.
Thank you, Sonali. My first question is to Professor Samarajiva. Professor, the free trade agreement came into effect on 1st whether it has conformed to the trade policy, national trade policy. Also, we saw a minister claiming that Sri Lanka has a period of 1 year to re-examine or to review the FTA and to suggest amendments. Is this possible?
I think it's a rather odd and unusual thing to appoint a committee months later to look at an agreement that was signed in the presence of the President himself. If there was some kind of intervention of that type needed, it should have been done before that. Furthermore, there is this concern about the chair of the committee. So I actually, last year, this was organized a People's Commission for National Policy on International Trade, was established by the Government Medical Officers Association, and they held hearings in, I think, March, April and May last year. And I was one of the people who presented evidence before this unofficial People's Commission. This commission was headed by the person who has been appointed as chair of this review committee. And it was very clear from the way I was introduced, as here is Professor Samarajiva, who's going to say something completely contradictory to what we've been hearing, even before I opened my mouth. That's what the chairman said. So that means that he had prejudged what I was going to say, and he had a particular view about what was orthodox statements before his commission. So in that light, I find it rather disturbing that this committee should have been appointed, because this actually brings into question the entire credibility of the government of Sri Lanka, because anytime we sign an international agreement, people will say, oh, maybe they will go back and re-examine the international agreement that they have signed, which I think is rather peculiar. So I think these need to be, the overall optics of these kinds of actions need to be taken into consideration and carefully considered before one goes out appointing committees.
So doesn't it also show that there hasn't been adequate discussion or consultation within the government itself? Now Mr. Vitarana said that, you know, before you sign a free trade agreement, Sri Lanka should have done its homework to establish legal mechanisms or improve regulation. So doesn't it show that there has been a lack of consultation within the government itself?
Now let's look at the past. We have been party to services agreements in the past, right? Sri Lanka has made commitments on telecommunications, financial services and tourism related services back in 1995 or 1996 thereabouts. When the GATS came into effect, these things were actually put in place. Now I have no idea what the consultation, I didn't live in the country at that time. When I came, these commitments, the services agreements came into effect, I honestly don't think that anybody recalls any kind of broad consultation being conducted before that. Then we had the Indian agreement, India FTA, again very little consultation. Now this thing we have been debating and debating from 2010 or 2008 when the Indian agreement was scuttled, right? So this has been an extraordinary, I've been actually praising this process, saying that this is the one occasion where complex economic matters have been discussed not in English, which is the custom in our country, but in Sinhala. And I have actually gone and presented and debated these issues in Jaffna, not in Tamil unfortunately, but I have had conversations, long debates on this in Jaffna itself. So there's an incredible amount of conversation that has been going on. So one of the reasons I have in these papers here, I was just going through my file and I found that at a point when we couldn't discuss the actual document, I had pulled out India's agreements with Singapore and taken the language from that to talk about it to the construction industry meeting, to tell them what kind of language we could expect. So I think there's been a lot of consultation. Now, I've been in public meetings where people have said we have not been consulted, and people from a chamber, the president of a chamber got up and said, I've been consulted. And I have circulated these documents. Some of these documents that were given to chambers have come to me because I have not been participating in these negotiations in an official capacity whatsoever. I have been only party to this from the outside, and when people like a Chamber of Commerce gives me a document and says, what do you think about this? So I think there's been plenty of consultation. In any country, this is the maximum amount of consultation you can have. Because you must remember, you know, this government had it in their election manifesto that they were going to sign these agreements. Countries were mentioned, India, China, Singapore were mentioned by name. I thought they were being foolhardy because everybody knows that Sri Lankans are very scared of trade agreements. But they had actually included in black and white in their manifesto. So they have a mandate to get it done. And my complaint, I think I've made this maybe keep on consulting, you'll never get anything done. A government has, in a democracy, a certain time period. The first few years of its term are when it has got to do these things. If anything, they've been too slow.
But if they were on the same page, there's no reason for the president to appoint a committee to look into an agreement.
Well, I don't know. I can't read the president's mind. I'm sorry.
My concern is this: we are not scared of free trade agreements. Sri Lankans are not scared at all. We have a practice of getting into free trade agreements long before. But here, if it's entered into a correct way, I am not in agreement that we should not have consultations prior to that. It is a must, because as it for any other act, we should know before why we should do this act.
Mr. Vitan, Professor Samarajeva says with this particular free trade agreement, the Singapore-Sri Lanka free trade agreement, there was very broad consultation before it. Do you disagree? Because you say you seem to be contradicting.
With the knowledge that I have, I'm not in agreement with that fact. But further, as my friend said, even his union was not consulted.
I don't have an organization.
Dr. Anasingh.
Dr. Anasingh said even his union was not consulted. So that's a fine living example. Apart from that, there's a protest. Even so many organizations, even the Bar Association, the GMO, and so many other organizations now come forward and say that we are not consulted. First of all, as far as this agreement is concerned, who consulted, who was engaged in this process? That's another matter that we have to be concerned of. That is, as the GMA had openly said, there was no officials who got the mandate proper to engage into this preliminary procedure. So first, there should be a people who come forward before the people, a set of officials with a mandate. The mandate should specify this is the parameters of the agreement, this is the scope, these are the objectives, and so forth. Then on that mandate, they have to call for consultation.
But Mr. Vitana, usually those parameters, the scope that you're talking about, what exactly this is what the negotiators discuss in their preliminary discussions.
Yes.
The negotiators of both countries.
Yes, there's a parallel exercise. Negotiations also should be there. Negotiation should be based on the requirements of the nation and the people.
So you feel that this agreement is not in favor, is not in keeping with the interests of the Sri Lankan people?
There are so many loopholes here. At the end of the day, what the product outcome of all this exercise?
Well, the government and the supporters of the agreement say that the outcome will be greater inflow of FTIs, that it will generate employment, that there will be technology transfer, and that there will be
for example, I'll take two examples. Now this specified, this relates to goods. Take goods. Now we get these agreements provide to import paddy. Now from where it should come? Now some who are proponents, who are defending this agreement, say, why, how can it happen practically? Singaporean, in Singapore you don't get paddy fields. But there's a mechanism, there's a path open up in this agreement to get the paddy from third country, a third state. So that is there. So for example, as far as the goods are concerned, you have to recognize the goods from invoice of a third, sales invoice of a third country. It's specifically stated here. So there are avenues as far as the goods are concerned of a goods of third country. So we have our industries, our producers have to compete. As far as the service sector is concerned, this has opened up avenues for third employees, workers, laborers, and so many other employees of third country.
Mr. Vitan, you just heard Professor Samarajeva say, and I think it has been reiterated several times, that it only opens up for intra-corporate transfers.
I can show you. I show you because these sectors are not specifically stated in this.
It's only intra-corporate transfer ease. So it's only companies that can bring in, and that too at management, expert or executive level.
Yeah, now there are 4 modes of opening.
I find it difficult to comprehend how a labourer would be at management or executive level.
If I summarize this, I can go to the specific clause and say this agreement is here if you are contesting. But it's like this. There are 4 modes that we are open as a opener. There are 4 modes, 4 ways. Now, one way is you can a foreign company, the state party can come as company, come establish a company, a corporation in the other country. Now,
Mode 3.
that's a mode 3. No, here it's a mode 4, mode 3. That is, here this provides for a Singaporean company which provides service, a manpower company, manpower service providing company come here and open up its company is authorized by this agreement. It's specifically stated in the schedules to supply services of so many other sectors, servicemen. That is not specifically stated there, but it is stated by reference to a number in the CPC.
No.
Yes, it's there.
No.
Are you sure, Mr. Itarna? Because, I mean, we constantly have the intra-corporate transfers.
I have
You
the
can get a manager
These are
from your
intra-corporate
company there to
transfers.
here.
No.
So a manpower company can bring managers, executives and experts. They can't bring laborers. They'll have to provide laborers from within Sri Lanka, or they'll have to bring laborers under a labor contract.
I'll show you.
Right.
It says, for example, it provides for placement and supply services of personnel, executive search services, CPC 87201. So, CPC, it refers to placement and supply services of personnel, CPC 87203. Now, that's a code that is specifically stated there. CPC refers to
Now, would you
several products.
also read
So,
what is the 4? 4 is unbound, unbound, unbound.
So, no,
That is mode 4 is unbound.
No,
When
mode
mode
3,
4 is unbound.
mode 3, none except
Except
the
for
horizontal
conditions.
So, what
So
are
these three
the horizontal conditions? For horizontal conditions, mode 3 to service supply through commercial presence must be after
Right.
registration.
Now,
under
please
Lanka.
go
So,
further.
after,
Hang on.
after-
Please go down.
So,
it says managers, experts.
that is
also
that is under mode 4. This is, I am concerned of mode 3.
horizontal says managers,
No,
experts.
don't mislead
No,
the
I'm
public.
reading.
No, don't
you
mislead the
can read
public.
it. You should read the entirety of the horizontal commitment.
That is in reference to mode 4.
So then read it. Read it in
Mode
total.
3, it says,
Read the horizontal commitment.
read the horizontal domain in reference to mode 3 is registration under relevant procedure. It's not mode 4.
So how is mode 4 unbound except for the following categories and subject to immigration laws of Sri Lanka?
Mode 4 is not
Business visitors,
applicable.
intra-corporate transferring.
Mode 4 is not applicable here.
Mode 3 is legal persons. Mode 4 is natural persons.
Yes.
So how can...
Mode 3 is the legal person.
Mode 4 is limited to
legal
business
person.
visitors.
Okay,
Professor
gentlemen,
Samar,
thank you.
I think Mr. Kitmina, I think
Yeah,
you
Kitmina, can
want
you
to chime
just
in on that.
share your views on
Sure.
this?
So there are 4 modes. And
Yes.
the question here is mode 3 and 4. Mode 3 is, like Professor Samarjeev has pointed out, the legal persons. So what that means is the corporation. So in kind of layman's terms, if Shangri-La comes and creates Shangri-La Colombo, that is mode 3. Right? So that's commercial operations in another country. So a Singaporean company coming to Sri Lanka and establishing. What Mr. Vitaran has a problem is with Singaporeans coming here, right? And that's mode 4, right? And that is, as is in the document, unbound. And unbound means that Sri Lanka is not making a binding commitment to liberalize mode 4 when it comes to these services. So the only thing that is being liberalized here is that we allow a Singaporean company that does placement and supply services to establish a branch here. And then it will hire Sri Lankans to work here and do, so for example, headhunting. So a headhunting firm in Singapore can establish a branch in Sri Lanka. That's all that is allowed, right? And then in terms of people, it's intra-corporate transferees at the top level. So laborers are not allowed for starters. But then when it comes to natural persons, it's unbound, which means that Sri Lanka has not liberalized mode 4 labor migration when it comes to these. So I think the problem is that, you know, there's a bit of a misalignment of how people are interpreting these, and I think for certain, as it kind of helps them, they kind of misinterpret it in that form. But it's important to kind of distinguish these different modes. I know it's technical, but in a very layman's term, mode 3 is when it comes to corporate or commercial presence.
Sure.
In mode 4, it's the presence of natural persons. And there's a very definite distinction there. This agreement liberalizes mode 3 under the horizontal commitments that are made. Mode 4 is not liberalized at all.
Thank you. Sonali, do we have time for a couple of questions
Sure,
to Dr. Ranasinghe?
absolutely.
Dr. Ranasinghe, Sri Lanka's trade in services, if I'm not mistaken, is about 13% of GDP, as opposed to Singapore's, which is at about 37% of GDP. You also were talking about how in Sri Lanka, you know, we haven't done a proper survey to see whether there is a surplus of engineers or a surplus of doctors or lawyers, or the professions that you mentioned. Don't you feel that with this free trade agreement that it could work both ways? That there are opportunities to go the other way as well?
Okay, can I answer the question that you discussed earlier before answering into this question? Now, this my friend Anthony Kanishka was also discussing about this mode 4 and mode 3 and mode 4. Now the commercial presence is mode 3. Commercial presence means, supposing if a Singapore company establishes a business here or buy a business which is already functioning in Sri Lanka, there is no intracorporate transfer does not mean only the executives, specialists, etc. It could be laborers as well, because presently under the present system, if you walk into a construction site in Colombo, any big construction site, you can find more than 50% of the people, those who are working here, are either from Nepal, India, China, or from various other countries, because they say there is a shortage of technicians, craftsmen, etc. in Sri Lanka. Therefore, they are bringing these people. Not because actually there is a shortage purely, because the thing is actually when a foreign worker comes here, when our worker works 8 hours, he works more than 12 hours because they are housed there. And also their salaries are much cheaper than our workers. And probably they don't have to pay. They don't pay EPF, ETF, gratuity, etc. So there are a lot of advantages of employing foreign workers in any industry in Sri Lanka than employing local staff. So that is one of the reasons actually why they employ foreign workers in the construction site. So supposing if a foreign company buys a business, let's say if they buy some business which is running business in Sri Lanka, or company or a factory, they can completely substitute workers from foreign workers. So therefore, although it says
Dr. Ranasinghe, I have a small question there. You said that if you already, like now in the present, you go to a construction site, you find more than 50% are foreign workers. If that is the case, if it's already happening, then how is the Singapore-Sri Lanka Free Trade Agreement allowing it to happen?
The problem is actually when you import labor for a specific job, it is quite different from engaging people from a free trade agreement. Because if it is from a specific job for a specific construction project, if there is any situation where the government decides to expatriate them, there is no restriction at all. But if you sign a free trade agreement, you are bound by certain other terms. So therefore, the conditions that they come are completely different from when they are working under a normal agreement. So then also I think probably I should discuss something about this dispute resolution also, because when a foreigner comes and do business here under the normal conditions, they are subject to the laws of the country. They'll have to go to, if they want relief, they have to go to courts of Sri Lanka. But all these agreements are covered by arbitration clauses. So the disputes will be resolved by an arbitration tribunal appointed by the parties. So arbitration tribunal will be laymen appointed by the parties, and sometimes they have been appointed by their legal firms. So therefore there is a greater disadvantage for Sri Lanka, because most of these disputes, they run into multi-million, disputes will be resolved by the arbitration. So therefore, unlike a person coming here and working here or engage in a business foreigner, where they have to seek assistance from the normal court system, they will be governed by a different law basically because of this free trade agreements. So therefore, working as a normal worker coming into work in a project is completely different coming under the free trade agreement.
There is a question from one of our viewers. He says 87205 labor, is it being liberalized?
Yeah.
87205.
87205. Yeah, may I come to that? There's the difference is, as the shortest answer to the previous question is, the difference is between the unilateral agreement, unilateral liberalization, and the bilateral liberalization. When you country can open up its market unilaterally without a free trade agreement, at the same time country can control it. When you go into a bilateral agreement, both countries are bound by that. That's why it affects the sovereignty of the country. They can't decide on their own without the consent or the agreement of the other party to alter or change terms of the agreement. When it comes to the number that you are referred to, 87205, that number is there under the modes, under our schedule of commitment as under sector or subsector in reference to the placement and supply services of personnel. So placement and supply services of personnel can be done in that sector. The market, the access has been given under mode 3. Mode 3, it says none except for horizontal conditions. When it comes to horizontal conditions, what is applicable to mode 3 is to register a company here. That's all. Then that company can engage in the business of placement and supply services of personnel under this code number. This code is the CPC code. It is not part of this agreement. It's a Central Product Classification of the UN 95. It is a separate agreement. So when you refer to that, 87205 includes so many, there's a list of personnel, included the supply services of construction workers, then when a company, a manpower service company, a person who's engaged in servicing, providing this personnel is established or incorporated here, it can do the supplies of supplying in the process of this personnel in this country as a manpower service supply company. So that's how foreign laborers of a third party, a country which is not necessarily Singaporeans or Indian or some other country, can come through this company, which is a Singaporean company, into the labor market here.
Now I have to add to this. I've got the relevant schedule open in front of me, and it says placement and supply services of personnel, CPC 87203, 87204 and 87205. Under limitations on market access, it says under mode 1, none. That means that it's completely liberalized. That's what the word none means in trade law. Under mode 2, it says none. That means it's completely liberalized, right? No restrictions whatsoever. Under mode 3, it says none except for horizontal conditions. So for that you have to go to the horizontal commitment. Under mode 4, which is what you would require in order to move natural persons, as previously clarified. So mode 3 is about moving companies. The second one is moving people. It says unbound. That means it has not been opened at all. If it was open, it should have said none. So this is completely false.
Professor Samarjeeva,
I'm sorry.
If I'm to comprehend if I have comprehended what Mr. Vitharanu was arguing just earlier, it appears that his argument was that Mode 3 has been manipulated in such a way as to open Mode 4.
Well, let me give you the scenario, right? So a Singaporean firm actually supplying laborers comes in and establishes itself under Mode 3 subject to the horizontal condition. Fine. That is, they have gone through the company registration process. They want to now they want to supply, what's the term? Placement and supply of service personnel, right? That's what they want to do. That's their business. That's why they came in under this section. So they have two options. They can take Sri Lankan workers and they can use them to provide the services. That is always possible. When Apollo came here under Mode 3 trade, not covered by a trade agreement, when Apollo came here, they employed most of their employees were Sri Lankans. Just a few doctors and a few managers were Indian. Most of them were Sri Lankans, right? Now, in this case, they will have some of those managerial personnel at the top coming in under experts, managers, etc., which are all defined terms. They cannot be defined to mean laborers, because this is actually defined terms, right? They give the big paragraphs defining each term. I can read them out to you if you want. Now, Mode 4, they cannot use the trade agreement. If there is a labor contract that has been separately arrived at, as was stated, under a unilateral kind of arrangement, saying we don't have workers in this area, we are bringing X number of workers from Nepal. The Singaporean firm can do that, as can any Sri Lankan firm. That's it. Not covered by the trade agreement, but possible.
So that's possible anyway. That's how it's happening
anyway
currently.
That's all I'm saying. Anyway possible for anybody.
But there's a difference. I said it's a unilateral. When you liberalize unilaterally, the country has always have control. Country can control over it. Country impose regular. Right. But when it bilaterally, you can't.
So bilaterally, all that has happened is if you do something, if you refuse to give a visa, a work permit to a manager, expert, or what's the other term? Executive. Yes, they have recourse. They can go back to their government. They can say, please raise this matter as a violation of the agreement that has been signed. But supposing that a labor contract has been arrived at, which is outside the agreement, I emphasize outside the agreement, something happens, they can't go back to the Singaporean government. They have to come and talk to the Sri Lankan government like anybody else and say, what can you do? We are stuck because this particular contract that we have signed is not enforceable.
So now, say, my friend, now we say, now why we are disputing, why this argument is? Because there had been we have not done our homework. If there had been a feasibility study, if there's been consultations had gone on, as in any other country does, I don't think it's unusual to have, to go into agreement like this without a feasibility study, without a consultation. Then, in the consultation notes we use in free trade agreements, when we are interpreting agreements, we use consultation notes to decide what the intentions were earlier. So if we had at least a feasibility study report, these arguments would not have been risen. That's why the people have protested. That's why His Excellency the President was compelled to look into this matter because of the this agreement.
Mr. Vitan, are you
because of the
still
pressure
confused?
of the unofficial opposition constituted by the GMOA.
No, not the unofficial. That's another misinterpretation.
Gentlemen, on that note, we need to go in for a short commercial break. You're watching Face the Nation. We'll be right back.